Criminal Law. Definition of terms. Part 5. Seduction. Seduction means enticing a woman to unlawful sexual intercourse by promise of marriage or other means of persuasion without use of force. Abduction is meant that taking away of a woman from her house or the place where she may be for the purpose of carrying her to another place with intent to marry or to corrupt her. Bigamy. Any person who shall contract a second or subsequent marriage before the former marriage has been legally dissolved, or before the former marriage has been legally dissolved, or before the absent spouse has been declared presumptively dead by means of a judgment rendered in the proper proceedings. Libel is a defamation committed by means of writing, printing, lithography, radio, phonograph, painting or theatrical or cinematographic exhibition, or any similar means. Slander. Slander is oral defamation. It is libel committed by oral, spoken, means, instead of in writing. The term oral defamation or slander as now understood, has been defined as the speaking of base and defamatory words which tend to prejudice another in his reputation, office, trade, business or means of livelihood. Misfeasance is the improper performance of some act which might lawfully be done. Malfeasance is the performance of some act which ought not to be done. Nonfeasance is the omission of some act which ought to be performed. Infanticide, the killing of any child less than 3 days of age, whether the killer is the parent or grandparent, any other relative of the child, or a stranger. Duel. It is a formal or regular combat previously concerted between two parties in the presence of 2 or more seconds of lawful age on each side, who make the selection of arms and fix all the other conditions of the fight. Mutilation means the lopping or the clipping off of some part of the body. Deformity is meant physical ugliness, permanent and definite abnormality. It must be conspicuous and visible. Arrest. A restraint on person, depriving one of his own will and liberty, binding him to become obedient to the will of the law. Proof. It refers to the accumulation of evidence sufficient to persuade the trial court. Quantum of evidence. The totality of evidence presented for consideration. Quantum of proof refers to the degree of proof required in order to arrive at a conclusion. Burden of evidence. The duty of a party of going forward with evidence. Burden of proof. The duty of the affirmative to prove that which it alleges. Collata matters. Matters other than the fact in issue and which are offered as a basis for inference as to the existence or non-existence of the facts in issue. Probative value. It is the tendency of the evidence to establish the proposition that it is offered to prove. Antecedent circumstances. Facts existing before the commission of the crime, that is hatred, bad moral character of the offender, previous plan, conspiracy, etc. Concomitant circumstances. Facts existing during the commission of the crime, that is opportunity, presence of the accused at the scene of the crime, etc. Subsequent circumstances. Facts existing after the commission of the crime, that is flight, extrajudicial admission to third party, attempt to conceal effects of the crime, possession of stolen property, etc. Confession. An acknowledgement of guilt. Admission. An acknowledgement of facts.